Hi, my name is Kristen Weeder. I chose to analyze Washington v. Glucksberg starting on page 502 of the textbook for this video argument. For those of you who need a refresher of the details, I will give you a brief summary of this case. Washington passed a statute that prohibited the aiding of suicide. Four physicians argued that terminally ill, mentally competent adults had a liberty interest in the right to a physician-assisted suicide as protected by the 14th Amendment. Ultimately, the court disagreed, saying that the right to a physician-assisted suicide was not protected by the 14th Amendment Due Process Clause. The physicians argued that the right to an assisted suicide is a fundamental right, state purpose, and must be narrowly tailored to advance that compelling purpose. The court identified several compelling interests the state had, including the preservation of human life, the protection of vulnerable groups from potential harms, and the protection of the integrity and ethics of the medical community. I agree that the state has an interest in preserving human life and in protecting vulnerable groups from harm, but I believe that the state has contradicted itself when it stated it had an interest in protecting the integrity and ethics of the medical community. The court allows, and has allowed, other medical practices to continue that may be damaging to the ethics of the medical community, but has decided not to bar these actions. One example is the court's determination that the Constitution grants a competent person the right to refuse life-saving nutrition and hydration if the court finds that they can provide clear and convincing evidence of his or her right to do so. This was the court's holding in Cruzan v. Director, Missouri Department of Health, a right-to-die case. In comparing Cruzan to Glucksberg, I failed to find a clear distinction between a physician removing a feeding tube pursuant to the patient's wishes and a physician administering lethal medication pursuant to the patient's wishes. While some may argue that removing a feeding tube is a passive act, while administering lethal medication is not, both practices bring about imminent death and have to do with the patient's right to receive a physician's assistance in their death. The court in Glucksberg supplements their argument that a state has an interest in protecting the ethics of the medical community, arguing that the American Medical Association has concluded that physician-assisted suicide could blur the line between helping and healing. In applying this argument to the removal of a feeding tube versus physician-assisted suicide, I do not see that one helps the patient while the other hurts the patient. In fact, I view both practices broadly as assisting a patient in their constitutional right to die. Proponents may argue that the holdings in Cruzan and other right-to-die cases help a patient because they employ a higher level of care by ensuring that there is clear and convincing evidence that one wished to not be kept alive artificially before pulling a feeding tube. I would argue that there is a higher likelihood of understanding what a patient wants in a physician-assisted suicide, as the standard of proof is more easily met. The physician would be potentially alert and cognizant enough to undergo extensive psychological evaluations. Their future quality of life could be assessed, and the patient could ultimately make their own decision on whether they would like to die. Another distinct example of the court allowing a controversial medical practice is abortions as allowed by Roe v. Wade. Here, the court argued that the state had a right in maintaining medical standards as well as preserving potential life and protecting maternal health. Ultimately, the court decided that the state only could regulate the abortion procedure to the extent that the regulation related to the preservation and protection of maternal health and potential life, ignoring the argument that the state had a right in maintaining medical standards. From these examples, it follows that while the state has a right to protect its citizens, the right to regulate the medical community's practices may not be presumed. These physicians are not necessarily arguing that physician-assisted suicide should be the norm, but that physicians that choose to assist suicides should be allowed to carry on with that practice. The physicians are essentially arguing that the medical community should regulate their own ethics and practices. In conclusion, while I believe the state's argument that it has a right in protecting the ethics and integrity of the medical community is contradictory to past decisions, I believe the argument that the state has a compelling interest in preserving human life and protecting vulnerable groups, and this is enough to determine that the state has a compelling interest in a patient's right to a physician-assisted suicide. I ultimately agree with the court that an assisted suicide is not a fundamental right. However, it seems that there are facets of this issue that are yet to be explored, and maybe one day physician-assisted suicide will be examined again.